Good evening, friends. And with a series of going live at 9 p.m., which is already doing very well, and especially once we have a speaker of immense knowledge like Justice K.T. Sankaran, a former judge from Kerala High Court. It's always a pleasure learning his special skills and knowledge sharing on Code of Civil Procedure and Limitation Act. As we have already shared that his sessions are also live available on his YouTube channel of K.T. Sankaran. So those who have missed, they can watch those webinars on his sessions of YouTube channel as well as on Beyond Law CLC, since we have done a lot of sessions with him. Despite his hectic schedule with his new assignment, he was kind enough to accede to our request. And therefore, today we are coming with the amendments made in the Act of Code of Civil Procedure in the year 1999 and 2002. Since it's late night, we will not take much time, and we will request Sir to share his knowledge. Over to you, Sir.
Thank you, Mr. Vikas. And thank you all the participants. Today's subject is important amendments to the Code of Civil Procedure by the 1999 and 2002 Amendment Acts. You are aware that the Code of Civil Procedure is more than 100 years old. It underwent many changes. Originally, the CPC was having sections continuously, just like CRPC. Later in 1908, it was changed to the present sections and orders and rules. And one major amendment of CPC was in 1976. Several amendments were. And thereafter, the major amendments are CPC Amendment Act 46 of 1999 and CPC Amendment Act 22 of 2002. What is important of these amendments is that when the 99 bill was introduced in the parliament, it was circulated for public opinion. At that time, I remember specifically, and I have also participated. Meetings were convened by the bar councils and bar associations all throughout India to have discussions. In our High Court, namely the Kerala High Court, a 3-day session of various bar associations was held. And item-wise it was discussed. Opinions were gathered and all were sent to the center. And at that time, the parliament thought, seeing the various opinions expressed by the various sections of the bar as well as litigating public, that some amendments require changes, further changes. Therefore, they made changes. Some of the provisions were deleted, some more provisions were added, and thus the 2002 amendment bill was there. Both these bills were introduced in the parliament simultaneously, and they were passed, and these amendment acts came into force on 1/7/2002. So a person who makes a serious study has to see what is in position before 1999, that is after 1976. Then what are the changes effected or sought to be effected by the 99 Amendment Act, and further changes made by the 2002 Amendment Act. You have to make a chart of it and make a study so that the study will be complete. And when these amendment acts were passed and they were introduced on 1/7/2002, even before that, it was the validity of the same was challenged by Salem Advocate Bar Association. Even before they went to Supreme Court to challenge the constitutional validity, there were protests and boycotts, particularly in the state of Tamil Nadu. and protests were all throughout India in various sections of the bar and the litigating public. And when the amendments were challenged before the Supreme Court, it came up for hearing before the Supreme Court, and two judgments were passed. One was passed in, please note, 2003 1 SEC 49, parallel citation AER 2003 Supreme Court 189. Name of the case is Salem Advocate Bar Association versus Union of India. When this case came up for hearing, the Salem Advocate Bar Association, the petitioner in the petition, sought permission of the Supreme Court to withdraw the case. Supreme Court did not allow. Supreme Court said that this is in the nature of a public interest litigation. These are in the words of the Supreme Court. By order dated 16/9/2002, the prayer to withdraw the petition was declined as the petition had been filed in public interest. Thereafter, what the Supreme Court did was, Supreme Court had already sought the assistance of senior advocate C.S. Vaidyanathan. And after hearing him, various provisions were considered, and ultimately it was held in paragraph 4. It is not a final conclusion. It is in the after hearing, and various points were discussed. And in paragraph 4, it has been said, we do not find that the said provisions are in any way ultra vires the Constitution. It was also held that legislative competence was there, and it is not violative of any provisions of the Constitution. Thereafter, various provisions were considered. We will discuss it later. But at the same time, the Supreme Court said, in the words of the Supreme Court, in our opinion, the suggestions so made merits a favorable consideration. Suggestions made by the senior counsel. With the constitution of such committee, a committee was constituted. Any creases which require to be ironed out can be identified, and apprehensions which may exist in the minds of the litigating public or the lawyers clarified. As suggested, the committee will consist of a sitting or retired judge of the Supreme Court and Justice M. Jagannath Rao was the chairman. Two members, the other members of the committee were Kapil Sibal, senior advocate, who later became a union minister. Arun Jaitley, senior advocate, who also became a minister of the union. C.S. Vaidyanathan, senior advocate. D.V. Subbarabu, chairman of the Bar Council of India. And the committee was given the right to co-opt members. And when it was said about some of the provisions, which we will discuss later, the Supreme Court thought that the committee should be given the power to consider all these things and to submit reports. Reports about how it should be implemented. The creases are to be ironed and how it can be implemented more effectively. Accordingly, the committee submitted 3 reports. Report number 1 was with respect to grievances with respect to the amendment. The report number 2, sorry. Report number 2, draft rules for ADR and mediation. Because when section 89 was considered, Supreme Court thought that some suggestions with respect to that matter also is required. Report number 3, model rules for case management. Model rules for case management. These 3 reports were submitted before the Supreme Court. Supreme Court considered these reports and the second judgment was passed in Salem Advocate Bar Association versus Union of India. We can for convenience sake call it Salem 2. The other is Salem 1. The second one, that is the present one, 2005 judgment, is Salem 2. 2005 6 SEC 344. 2005 6 SEC 344 parallel citation AIR 2005 Supreme Court 3353. In the second one, more detailed consideration was made with respect to several provisions. Some of the provisions were discussed in Salem 1 and Salem 2, while some others were considered only in Salem 1 and some others were considered only in Salem 2. I will give a clear picture about it. Now in Salem 2, in Salem 1, Salem 1, Section 89, one of the major amendments. What is Section 89? 89. The nature of the litigation was changed. And stress was laid on alternative dispute resolution. Settlement of dispute outside the court. And what is said is that where it appears to the court that there exists elements of settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations, the court may formulate the terms of a possible settlement and refer the same to 4 categories of institutions. 1 is arbitration, 2 conciliation, 3 judicial settlement, including settlement through Lok Adalat, and 4 mediation. And with respect to these provisions, with these alternative dispute resolution mechanisms, what are the provisions of law which are applicable are stated in subsection 2 of section 18. Lok Adalat is a Legal Service Authority Act, Arbitration Conciliation Act, and mediation, compromise, etc. And incidentally, I may say that to understand properly the scope of section 89, not only Salem 1, but a more detailed judgment focusing attention on section 89 is that is Afcon infrastructure. Afcon infrastructure versus Cherian Worky Construct. Afcon Infrastructure Limited versus Cherian Worky Construction Company Private Limited and others. Cherian Worky Construction Company Private Limited and others. That is 2010 8 SEC 24. That case arose like this. Kerala High Court decided a point. What was the point? The point was whether unwilling parties and also who did not enter into an arbitration agreement can be compelled to go for arbitration, exercising the power of the court under section 89 CPC as amended by the Amendment Acts. Kerala High Court held that even unwilling parties who did not enter into an arbitration agreement can also be compelled to go for arbitration. That is the scope of section 18. That was challenged by Afcon Infrastructure Limited before the Supreme Court. The Supreme Court reversed the decision of the Kerala High Court and held that an unwilling party cannot be compelled to go for arbitration. And while deciding it, the scope of section 89 was considered threadbare, and certain suggestions were made, and also which cases should go for settlement, which should go for mediation, which should go for arbitration, etc., were stated in clear terms, which cannot be referred to arbitration, which can be referred to arbitration, which shall be tried by the court, etc. And I am not referring to in detail Afghan infrastructure. You are requested to go through it word by word, very detailed judgment. And in the course of discussion, the court also said that some clauses C and D of subsection 2 shall be interchanged. That is for judicial settlement. The word mediation, it shall be read as mediation. And for mediation in clause D, it shall be referred to as judicial settlement. Whatever it is. Various provisions, various angles were considered in Afghan infrastructure. For the purpose of this discussion, I am not touching upon that decision and the various nuances of the scope of section 89 now. I am referring to Salem 1 in respect of section 89, paragraph 8 to 12, paragraph 8 to 12 of Salem 1. Supreme Court, I will read only the relevant portion. Para 9, keeping in mind the law's delays and the limited number of judges which are available, it has now become imperative that resort should be had to alternative dispute resolution mechanism with a view to bring to an end litigation between parties at a generic stage. Then para 10, all this means is that the effort has to be made to bring about an amicable settlement between the parties. If the conciliation or mediation or judicial settlement is not possible, despite efforts being made, the case will ultimately go for trial. And then the committee was appointed, committee was directed to consult, etc. etc. That is, 89 was considered in paragraph 8 to 12. And along with section 89, you have to see order 10, rule 1A, 1B, and 1C. Order 10, rule 1A, capital A, 1 capital B, and 1 capital C also. Then only it will be complete. And then another point which is discussed in Salem 1 was with respect to section 100 capital A. 100 capital A. 100 capital A. Before referring to 100 capital A, I have to say that when an appeal is filed before the High Court, and if it is heard by a single judge, going by the High Court rules of the particular state, and in further appeal lies to the High Court before the division bench. On the other hand, depending upon the valuation, if it is to be heard by a division bench, then no further appeal. This was the position. 100A, no further appeal in certain cases. That is, states that notwithstanding anything contained in debtor's pattern for any High Court, or any instrument having the force of law, or in any other law for the time being in force, where any appeal from an original or appellate decree or order is heard and decided by a single judge of High Court, no further appeal shall lie from the judgment and decree of such single judge. This was the amendment. And the constitutional validity of the same was challenged as the Supreme Court said 100A, paragraph 13 to 15 of Salem 1. Paragraph 13 to 15 of Salem 1. Supreme Court said, where regular first appeal is so filed is heard by a division bench, the question of there being an intra-court appeal does not arise. Paragraph 15. It is only in cases where the value is not substantial that the rules of the High Court may provide for a regular first appeal to be heard by a single judge. In such a case, to give a further right of appeal, where the amount involved is nominal, to a division bench will really be increasing the workload unnecessarily. We do not find that any prejudice would be caused to the litigants by not providing for intra-court appeal even where the value involved is large. In such a case, the High Court by rules can provide that the division bench will hear a regular first appeal. No fault can thus be found with the amended provision 100. So that was approved. 100A was approved. So it was difficult to comprehend. When the valuation is less, it will be heard by a single judge, going by the High Court rules, letters patent. Otherwise, a division bench. When it is heard by a division bench, no further appeal is there before the High Court, and the party has to go before the Supreme Court. On the other hand, cases having less valuation heard by a single judge, there is a further appeal in the High Court itself. That is not proper. That will drag on, prolong the litigation. And therefore, the amendment was correct. Amendment was necessary. Supreme Court in Salem 1 said so. Then the other amendments I will consider, I will discuss in common, both. So we will go by section wise to the extent possible. To the extent possible. Section 26 and Order 6, Rule 15. Section 26 and Order 6, Rule 15. Salem 2, Paragraph 4. Salem 2, Paragraph 4. What is Section 26 and Order 6, Rule 15? Section 26. Prior to the insertion of the provisions, there was no requirement of filing an affidavit. But now, after the amendments, which came into force on 1/7/2002, an affidavit should be filed along with the plaint. That is contained in Order 6, Rule 15.2 and 15.4 and Section 26.2. Supreme Court said in paragraph 4, the affidavit required to be filed as amended under Section 26.2 and Order 6, Rule 15.4 has the effect of fixing additional responsibility on the deponent as to the truth of the facts stated in the pleadings. It is, however, made clear that such an affidavit would not be evidence for the purpose of trial. Further, on amendment of the pleadings, a fresh affidavit will have to be filed in consonance. So this is Supreme Court judgment also is to be considered. Whenever an amendment is filed, amendment application is allowed, a fresh affidavit is required with respect to that also. Next is Section 39.4. Section 39.4. Considered in Salem 2, paragraph 22 to 24. Paragraph 22 to 24. What is Section 39.4? Section 39 provides for transfer of decree. When a decree is to be executed by arresting a person or attaching and selling a property outside the jurisdiction of the court, or there may be some circumstances where it may not be proper to execute it in that court which passed the decree. The provision provides a mechanism for transfer of decree to another. For considering this, you have to see Section 37, the definition of the court which passed the decree, and 38, Section 38, which provides that a decree may be executed either by the court which passed it or by the court to which it is sent for execution. That sending for execution to another court is contained in section 39. In section 39, subsection 4 was added by the CPC Amendment Act of 2002, which provides that nothing in this section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of its jurisdiction. This was considered by the Supreme Court. Supreme Court approved it. This was the position of law even before the insertion of subsection 4. But there was some conflict of opinion among the various judgments of various high courts. Therefore, it was thought by the Parliament that a clarification is required. And that is why this amendment has been introduced. In the objects and reasons to the Amendment Acts, it is stated that this is only a clarificatory amendment. There are such amendments. In Order 21, Rule 32, there is an amendment which is also Parliament in the statement of objects and reasons. It is stated that it is only a clarificatory. Certain clarification was made. This was the position law even before, but it was not specifically stated. Then the Supreme Court also considered whether this provision runs contra to Order 21 Rule 3 and Order 21 Rule 48. That was also considered. Whether it overrides or whether harmonious construction is required, etc., was considered by the Supreme Court in paragraph 22 to 24. Conclusion at paragraph 24. Section 39, in paragraph 22 last, the question is whether the newly added provision prohibits the executing court from executing a decree against a person or property outside the jurisdiction, and whether this provision overrides Order 21 Rule 3 and Order 21 Rule 48, or whether these provisions continue to be an exception to Section 39(4), as was the legal position before amendment. And conclusion is in paragraph 24. Section 39 does not authorize the court to execute a decree outside its jurisdiction, but it does not dilute the other provisions giving such power on compliance with the conditions stipulated in those provisions. Thus, the provisions such as Order 21 Rule 3 or Order 21 Rule 48, which provides differently, would not be affected by Section 39(4). What is Order 21 Rule 3? Land situated in more than one jurisdiction. Whether which court will have jurisdiction? Both the court will have jurisdiction. What is Order 21 Rule 48? Attachment of salary and allowances of servants of government or of railway company or local authority. There the power is there to execute even outside the court. Whereas 39(4) says that the court has no such power. The other is in orders and rules. Sections will prevail. And if there is a contradiction, the orders and the rules will go. Sections will prevail. That is why the Supreme Court considered whether it has any overriding effect or whether there is any contradiction. And the ultimate conclusion is that it is not so. They operate in different fields. This is in short Section 39(4). And you have to also consider transfer of decree. Along with this, Order 21 rules 5 to 8 also may be considered. Next is cost. Section 35, 35A, 35B, and 95 were considered. In paragraphs 36 and 37, 35 provides for costs. 35 says that the cost shall be in the discretion of the court. The cost and incident to all suits shall be in the discretion of the court, and the court shall have full power to determine by whom and out of what property and to what extent such costs are to be paid, and to give all necessary directions for the purpose aforesaid. The fact that the court has no jurisdiction to try the suit shall not be a bar to the exercise of such power. These are all what is stated in section 35. 35A provides for compensatory costs. Sorry, I'm running now. Compensatory costs. What is compensatory cost? In a suit or other proceeding, including execution proceeding, but excluding appeal or revision, where the claim or defense or any part of it is false or vexatious to the knowledge of the party. False or vexatious to the knowledge of the party. The court has power to award costs by way of compensation. And the maximum that can be awarded is 3,000 rupees. Whereas under section 35, there is no such ceiling. Probably by the rules, what are the costs to be awarded, there may be provisions. And 35B, cost for causing delay. That is a provision which was introduced in 1976. Reasonably sufficient to reimburse the other party for what fails to take steps, and therefore the case cannot be taken up. Obtains an adjournment unnecessary to produce evidence. These are grounds on which the cost for causing delay can be granted. There is also no ceiling provided, and it shall not be on payment of such costs before the next following date of such order shall be a condition precedent for further prosecution of the suit or further prosecution of the defense. And these were considered by the Supreme Court. Scope of these were considered by the Supreme Court in paragraph 36 and 37. In para 36, in the circumstance mentioned 35B, an order may be made requiring the defaulting party to pay to the other party such costs, which is, in the opinion of the court, be reasonably sufficient to reimburse the other party in respect to the expenses incurred by him, etc., etc. The award of cost of suit is in the discretion of the court under 35. 35 and 35B, there is no upper limit of the amounts of costs awardable. Then section 95 was also considered. What is 95? Compensation. Two conditions are there. When in a suit, an order of attachment or injunction is obtained on insufficient grounds, or where a suit is dismissed and there was no just and reasonable cause to file it. These are the conditions. Where in a suit in which an arrest or attachment has been effected or a temporary injunction granted, then two clauses A and B, it appears to the court that such arrest, attachment or injunction was applied for on insufficient grounds, or the suit of the plaintiff fails and it appears to the court that there was no reasonable or probable ground for instituting the same. In either case, the court can award compensation on the application of the defendant, and the maximum was 1,000 before the amendment, and now it is 50,000. And it is provided in subsection 2. An order determining such application shall bar a suit for compensation. Whereas under section 35A, 3,000 is the ceiling limit. But you may file a suit, and if compensatory cost is awarded under 35A, that also will be taken. And the compensatory cost under 35A is not a bar to the criminal action, if any. This is 95 up to 50,000. The compensation can be awarded in the same procedure. No separate suit is required, no case is required, no protracted trial is required, just an application. That is amendment. And in paragraph 37, wherever costs are awarded, ordinarily the same are not realistic and are not nominal. When section 35(2) provides for costs to follow the event, it is implicit that the costs have to be those which are reasonably incurred by a successful party, except in those cases where the court in its discretion may direct otherwise by recording reasons therefore. So reasonable costs, and there are several decisions of Supreme Court which are also listed in as footnote, where the Supreme Court awarded exemplary costs for adopting delaying tactics. So in short, the attempt was to reduce the litigation, to reduce the time, and to reduce the cost of parties. Whether it has been achieved or not is a different thing. But an honest attempt was made by such amendments to protract, to avoid two-tier litigation sometimes. That is particularly when amendments were made in 1976, not 99 and 2002, with respect to execution proceedings, resistance, removal of resistance, etc. Order 21 Rule 97 to 104, Order 21 Rule 58, etc. Another suit was avoided, and the same suit itself, all these questions can be decided. So the purpose was that. Now, next is section 89. I said Afghan infrastructure, etc. I said that is in Salem 1. Section 64(2). That is in paragraph 25 of Salem 2. 64 says when there is an attachment, any private alienation will be invalid. 64. Private alienation of property after attachment to be void. An attachment is made. A files a suit against B and gets an order of attachment in respect of an involved property. And he cannot, the defendant cannot transfer the property contrary to such attachment. And when it is contrary to such attachment, it shall be void against what? Against all claims enforceable under the attachment. So even if a transfer has been made, to the extent it is covered by the claim in the plaint, it will be void. Third party cannot say that he was not aware of it. But a subsection was added by the amendment of 2000. Sometimes what happens is, see, take a case. Battery is running low. Seek your permission to put on. I forgot. Thank you. Yes. See, A files a suit against B. Gets an order of attachment. That suit is really false. Vexatious. For what purpose he has done it? To prohibit the defendant from selling his property to a third party for a good price. A has a property. The neighboring property belongs to B. A has an eye on that property. But B is not prepared to sell that property to A for a throwaway price. He wants good price, which A is not prepared to shell out. So B is compelled, B is otherwise driven to sell the property to C. At that time, A files a suit against B, a frivolous suit, false suit, saying that some money is owed by B. He has to get a debt from B, and he says that he is going to sell that property, which is true, gets an attachment. And once an attachment is made, B cannot sell it to C. Contrary, he can sell it, that will be void only to the extent of this claim under the claim. If C says that I will deposit that money, that is an end of the matter. But it can be prohibited. When there is an attachment, there will be entry in the sub-registrar's office, and so many queries will come, and it will be difficult. Nobody will purchase a property which is entangled in litigation. So to avoid that, the Parliament thought an amendment is required, and that is section 64(2), which says nothing in the section shall apply to any private transfer or delivery of property attached or of any interest therein, made in persons of any contract or such transfer or delivery entered into and registered before the attachment. Entered into, if there is a prior agreement. See, I will give an example. A entered in agreement with B to purchase B's property. They are neighbors. But thereafter, C offered a better price. Then B, ignoring the agreement between A and B, goes to sell the property to C. At that time, some litigation arose and the property is attached. And if the agreement is unregistered, nothing can be done. The attachment is made, it will be the private transfer made by B to C will be void. But if there is an agreement already which is registered, it can be done. If the agreement between B and C was registered, it can be done. That is the amendment. So, prior agreement, paragraph 25 of Salem 2. And what is said is, if the contract is registered and there is subsequent attachment, any sale deed executed after attachment will be valid. If it is unregistered, the subsequent sale after attachment would not be valid. Such sale would not be protected. There is no ambiguity in subsection 2 of section 64. The concept of registration has been introduced to prevent false and frivolous cases of contracts. Sometimes, after an agreement was entered into between A and B, B wants to sell the property to C. He creates a false agreement with the prior date. Stamp papers are, if it is unregistered document, an agreement can be written on stamp paper. Stamp papers of prior dates are available, and a document can be created, and then he cannot sell it to C based on that prior agreement, because after the attachment, once the attachment is made, private transfer cannot be. But if that agreement is registered, notwithstanding that there is attachment, the party can sell it. This is the amendment, which is good. Really, it will help the litigants who are having a genuine litigation, genuine ground. On the other hand, unscrupulous litigants can be prevented from manipulating things and putting forward false agreements. Next is 100A, I already said. Then section 80. Section 80, Salem 2, paragraphs 38 and 39. Then one may ask a question, what is amendment made to section 80? No amendment was made. But the Supreme Court considered the scope of section 80 and said in paragraph 38 and 39. 38 and 39. A notice, what is section 80? Provides that prior notice of 2 months is necessary where the suit is against a government or a servant of a government where government is liable. 2 months prior notice is required. And normally the government will not send any reply. This is not proper according to the Supreme Court. Why such a provision is there? The government to settle it if it is to be paid. Some contractor sues the government for the balance under the contract. If a notice is issued, without notice he cannot file it unless there is an urgent relief. He cannot file it without notice. So a prior notice is required under section 80. Why it is so? Because once the notice is received, the government, if the claim is genuine, can settle it and avoid a litigation. Or some sort of a settlement or compromise is possible. Or if lesser amount is due, he can be told that you are having a claim for a lesser amount and the government is prepared to pay it. All these are possible by notice, reply and further action. But the government, as usual, almost all governments, they won't reply. And litigation comes and takes so much of time. In paragraph 39, these provisions cast an implied duty on governments and states and statutory authorities concerned to send appropriate reply to such notices. Having regard to the existing state of affairs, we direct all governments, central or state or other authorities concerned, whenever any statute requires service of notice as a condition precedent for filing of a suit or other proceeding against it, to nominate within a period of 3 months an officer who shall be made responsible to ensure that replies to notices under section 80 or similar provisions are sent within a period stipulated in the particular legislation. The replies shall be sent after due application of mind. Despite such nomination, if the court finds that either the notice has not been replied or the reply is evasive and vague and has been sent without proper application of mind, the court shall ordinarily award heavy costs against the government and direct it to take appropriate action against the officer concerned, including recovery of costs from him. This is what is said. Though there is no amendment in 99 or 2002 with respect to section 80, the court considered that also. I think with this we'll close it now. We'll have another part of this subject on some other day which is convenient to all. Thank you.
We're just checking it out as to whether we have some question on the YouTube or this.
Pardon?
I was just checking it out on the YouTube as to whether we have any questions. Somehow there's no question, but otherwise it's being well received on the YouTube. And on the chat box also we don't have. So thank you, sir. And good night to all the participants who have been watching our webinar. And Justice K.T. Sankaran's sessions are always well received. And that's why we'll take the second part of the session. And despite the busy schedule, we have taken these sessions at the late nights so that people can actually understand the law in the right perspective. I'm just seeing a colleague of mine, a former session judge, Mr. Mehta, is there. I will ask him to share his thoughts because he has also taught in the Chandigarh Judicial Academy. Unmute, Mehta sahab.
Thank you, Vikasji. Good afternoon, Your Lordship, and all the worthy participants. Hope I am audible enough. Well, it was a wonderful experience. At least I thought of being back to the basics. Day one of my law college, when these niceties were taught to us, I'm very sure that the participants would be taking full advantage of rich experience of his lordship, and their skills would be better than ever before.
Thank you, everyone. And tomorrow we will be having a book launch by Justice Oak, a sitting judge of the Supreme Court of India. So do stay connected with us tomorrow at 5:30. The book is written by Mr. Yuvraj Narvankar. The book is Fundamental Principles of Electronic Evidence, the basic law manual. So do stay connected with us tomorrow at 5:30 for the book launch. Thank you, everyone. Stay safe, stay blessed. Namaskar.